My name is Angela Allen Bell, and I'm a law professor at Southern University's Law Center in Baton Rouge, Louisiana. I'm also a licensed attorney in the state of Louisiana and have been now for nearly 30 years. And most people would describe me as an activist scholar and an expert on the interplay between race and law.
Wow, that's truly amazing. I have to ask you, when did you develop this passion for law? Does it run in your family, or were you the first to do it? And when did you kind of catch that bug?
Well, I definitely don't have any other lawyers that were around me growing up. But what I did experience growing up in New Orleans, Louisiana, was lots of poverty, and learned very early on in my life what disadvantage does to a person over the course. So I started seeing children that were in school with me that were the product of generations and generations of poverty and families who had never owned a vehicle, and how just not having access limited people who had tremendous talent, who never got to the places that I got simply because of the access I had. So, because I was always aware of what marginalization and poverty and othering does to people, I started thinking along my journey, how would I play a role in dismantling systems that exist like this? And I considered social work very strongly, but leaned into law because I saw the reach that it had for making policy changes and, of course, legislative changes. And my career has not been linear. So I certainly didn't start off where I've ended up. I began my law career as an attorney working inside of the judicial branch. And I spent my first 10 years doing that. And I learned a lot, and I'm grateful for the experience. It taught me so much about law that law school, of course, never mentioned. And that really shaped the next stage of my life, because I was not able to pursue any of my personal passions when I worked inside of a court. It's important that folks who work in the judicial branch have the appearance of neutrality. So once I was able to leave and start making public positions and writing and expressing my views and thoughts, academic life was a natural fit for me, and that really, I think now the order of things were divinely inspired.
Wow, that's amazing. I mean, it definitely takes a lot of courage to even venture into that field for several reasons. You got to be smart for sure, but you got to be courageous too. Got to be brave.
News that I was watching this morning continues to show a pattern across the United States at this moment, where elected officials who really are loyal to any type of justice agenda, there's a move to really silence those folks, either literally or figuratively. And so I'm watching that in the state of Louisiana. And then, of course, this morning, seeing the same across the country. So, courage is something I certainly never considered doing the earlier part of this work. But as I now understand the harm that can visit a person that challenges the prevailing narrative, I'm certainly agreeing with you. Courage is a part of this life, for sure.
So I wanted to ask you about that as well. Like, what is the importance of attending the HBCU, especially for our people in 2024? Because a lot of times people take history for granted. They don't see the value in it, but it could be very empowering and uplifting.
Oh, I absolutely agree with that. And I also think it's something important about being in spaces where people understand and even share some of the common struggles. For example, I was talking about yesterday to an audience, about the dynamic that happens during jury deliberations. An example I gave is that, as a Black female, my experience in this country with the intersection of race and gender is unique. And no one who is not a Black female has that lived experience. So when you walk into an HBCU and you're housed on a campus where everybody understands your lived experience. You don't share the burden of being othered or having the duty to teach or explain or defend that you may have when you're the minority in other environments. But the other part of that is that, as I age, I am beginning to really see and testify to what my elders always said to me, which is that history repeats itself. And so, in these kinds of spaces where it's safe to talk about race and diversity and oppression, the lessons that are taught are often indicators and templates for how to prevent the same things from reoccurring in the future. So, for example, one of our legendary lawyers, the late Johnny Jones, I have a case that I teach my constitutional law students where he was trying to figure out how to fight segregation. And he tried the traditional routes, they didn't work. So he started getting creative and thinking maybe this is a way I can test the Commerce Clause. And so I use that case not just to teach the Commerce Clause, but to teach the innovation, the creativity, and the duty to disrupt any systems that oppress that exists when you are a graduate of an HBCU. So it's way more than just the history. It's the experience being in a collective body of people who understand and know how to nurture your struggle and to support you as you go through it. But it's also these HBCUs have missions. They were started for purposes. And so if there is fidelity to that mission, you don't go to an HBCU and leave the same. You go to an HBCU and receive a charge when you leave that you owe a duty to make the country better than you found it. And so that is all a part of the precious calling at an HBCU. And people often ask me, with all the things you've done, why do you want to stay at this little old HBCU in Louisiana? And my answer is always because that is where I belong. And so I appreciate you recognizing the richness of those kinds of spaces. And I am honored always to be a part of that legacy for the students that come under my tutelage.
Definitely, definitely. Now you're an author as well, right?
Over the years, expanded the things that I would write. And so I have started off doing law review articles that are purely for academic journals. And then I started to realize when I would go out in the community to do the work that I do in the community, a lot of times the community is not going to have the time to read those long academic journals. Sometimes they don't really have the skill to process all of the, very detailed analysis and case law that goes into that. So often what I have learned to do is that, my work is in different spaces. And so I am really a customer service agent for those audiences that I'm going to go before. So if I'm in the community, they need something different from a law review article. And so I've done op-eds, and now, of course, I've done what was supposed to be my first book. It got so long that it has now a series of books. And so I am very honored to be here to talk to you about this series of books involving race and justice. And I say in Louisiana, but truthfully, it's in any system that fails. So it could be in another state, could be in another country. It doesn't have to be the legal system. It could be the educational, medical systems. Any system that fails, these books speak to that experience.
Wow. Okay. Okay. Now, what's the name of the books, and where can people find them? What's the best place for them to get them?
So there are three in the series. The first two are now available. The first one is called Under Indictment: Race, Juries, and Justice in Louisiana. And I'm not sure if you can see this, but I'm trying to hold that up. The second one is called Diversity in the Jury Box and Beyond, a formula for transforming Louisiana's legal system. Both of these books are available at Walmart.com, Amazon, Barnes and Noble, and all of the other traditional online sellers. They should be in stores also by 2025, but at this moment, they're all available online. And then the third book in the series is called The Summons. It will be out before the end of 2024.
Wow. Okay. Okay. Now I wanted to ask you about the what is it? The non-unanimous juries in Louisiana. I just kind of found out about this not too long ago. I don't know if you're familiar. It was a musician from New Orleans. I think he had got into some trouble. He was ultimately, not guilty, but I guess just because, it wasn't enough jurors to, to prove he was innocent to vote in his favor, he ended up doing 20 years in prison. So how does that work, and how have you worked to change that?
So I think you may be speaking about the C murder case, because I think he has one of the more high profile cases of this. But I do want to emphasize the range of folks who have been harmed by this system. It's extremely broad. There are women who happen to be mothers and grandmothers who are victims of non-unanimous juries. There are people who are non-citizens, people who are non-English speaking, who are victims of non-unanimous juries. There's one guy that was in an automobile collision that the news describes as a road rage incident, but it involved a famous Saints player. He was convicted initially by non-unanimous jury. So the range of folks is broad. And the second thing I want to be sure we understand is that we did change our law in 2018, and I was a part of that advocacy team to do that work. But when the law changed, it was not retroactive, it was prospective. So what the legislator said is from January the 1st of 2019, all of the felony trials or all of the criminal trials are going to have to be by unanimous jury. But at this moment, while we're speaking in September of 2024, there are over 1,000 people who remain in Louisiana prisons who are victims of these non-unanimous juries because their convictions have become final before the law changed. And of course, the law didn't change to give them any protection. And as this has been litigated up to the Supreme Court of Louisiana has said, we're not going to do anything about it. The legislature in Louisiana has said, we're not going to do anything about it. But it is important to know that the Supreme Court of the United States said, Louisiana, if you want to fix this, it's your problem. You created it, and you certainly have the right to fix it. So it is not that legally Louisiana can't fix it. It is that the will to fix it does not exist. Juxtaposed with Oregon, the only other state that was using non-unanimous juries, and you see a very different outcome. In Oregon, the officials there said that, once the Supreme Court said to us that this was illegal, we're going to do our part to remedy it. Not only did they look at it from a legal standpoint when they tried to find solutions, but they also looked at it from the standpoint of racial healing, restorative justice, and they acknowledged that there was bad intentions on the part of Oregon officials when they changed their law. There was discrimination involved, and because of that, they wanted to take ownership of this history and rewrite the narrative. So I applaud them for being forthright about the history and trying to remedy the history. Louisiana is not in that business. We are unwilling to confront history. In fact, there is a move here to not even mention race, not even talk about diversity, to just pretend none of this stuff happened, which is impossible because it did happen, and the remnants of it happening remain with us today.
Now I can ask you, do you know, or have you even looked to how many cases or how many people could this ultimately affect if they were to, rectify the situations?
Yeah, so that number is at least 1,000, perhaps 1,500, but there's two other small points about this. There were so many accused people in Louisiana who were petrified to go before juries here because juries are primarily white, because our sentences are extensive and extreme. People took the odds and said, what's the better outcome for me? Should I just take a plea bargain and know that I'm going to serve so many years versus go before one of these non-unanimous juries and have no idea what's going to end up happening to me? So when you ask me for a number, I can certainly tell you that it's around between 1,000 and 1,500 people. But I want to make sure that I don't overlook the folks who I can't count because they were incentivized to take plea bargains. And so those folks are not recognized as non-unanimous jury folks because they didn't have a non-unanimous jury. So I want to make sure we say that. And also for people around the country or out of the country who listen to this and not even know what a non-unanimous jury is, I do want to explain that it's the practice of calling 12 people out for jury service and saying to one or two or three that you get to cast a vote, but we get to ignore what you say. So in Louisiana, it was initially back in 1898, 9 people could carry the vote and you could ignore 3. And then in 1974, we changed it so that we could ignore 1 or 2. So our non-unanimous jury system allowed convictions on the vote of 10 or 11. And I do want to be clear, we're talking about life sentences. We're talking about very serious felony charges that we were allowing these non-unanimous juries to happen. The other thing that I want to be sure we understand is that this is really not about just the word jury as if that is some routine conversation. This is actually about the Sixth Amendment to the United States Constitution. So when we talk about non-unanimous juries, what we're really talking about is a state deciding that it's going to disregard the federal Constitution. And if it can do it in the instance of juries, it can certainly do it in other instances. So that's one of the reasons that people should be alarmed. But the secondary reason is that there is a body of research, very compelling research that tells us that there is something about getting the right composition of folks in the jury box and allowing them to deliberate under the proper set of circumstances. What we know from that research is that when you use these non-unanimous juries, more than likely they poll immediately and they will say how many people want to convict. And if they have 10, there is no deliberation. That is one of the dangers of these non-unanimous juries, because oftentimes those 1 or 2 people who are trying to raise reasonable doubt have valid points that could actually change the course of these convictions, but they're not considered or heard. The other thing the science tells us is that when we do rely on the unanimous vote of 12, the process is going to be a little bit slower, because the people who are raising the reasonable doubt are going to raise questions that makes the other folks think and have to respond. And in that dialogue, some people are going to abandon their original conviction and change and say, now that you bring this point up, I see this differently. In that dialogue, some people are going to remember details that other people didn't remember. And as that exchange happens, it enhances the outcome. So we know that just that discussion amongst people who are different, and I want to stress that, because if we get 12 and they're all the same 12, there's no diversity in that jury box. What we need is 12 who are diverse. Diverse meaning different ages, different races, different social, financial, economic, environmental conditions, so that those discussions are enhanced by the difference of ideas. And so what is problematic about this is many of these people who we speak of when you ask for a number, these are people who might, I have one guy that I cited in the book, my the diversity in the jury box book, his deliberations was under 15 minutes. And this is a guy doing a life sentence. Just try to reconcile. This is a man who provided for his family, worked in a plant, and exploded because his wife was having an affair, which most people certainly don't excuse or rationalize, but they recognize that that might be manslaughter and not murder. There were at least one juror who was leaning toward not guilty, but because of the non-unanimous jury system, her vote didn't have any weight and she was disregarded, and they wouldn't even listen to her during deliberations. So that's just one good example that I cite, but throughout the book, I profile cases and cases of people who've been victim of these non-unanimous juries to help people understand this is not about being soft on crime. Actually, this is about public safety, because if you're sure you have the right person, then we know the public is safe. But if you've made a mistake and you have the wrong person, public is not safe. So the public should be very interested in this conversation simply for public safety reasons, because the science tells us we should be dealing with this, as well as the Constitution of the United States.
Yes, indeed. I appreciate you taking the time to break that down. It's definitely still relevant conversation. It was a brother, I believe, a few days ago that they said, he was executed, but somebody came forward and said that they lied on him or they got some DNA evidence and they didn't want to, utilize that to, let him go. So I thank you for that. I wanted to ask you about you got a chance to work with one of the members of the Soledad brothers. If you could talk about how did that come about, and what was that experience like?
Yes, I did. That is also one of the joys of my life as an activist scholar. But his name is John Clutchette. He is the only remaining member of the Soledad brothers who is alive. And that case really is a part of the nation's history with Black Panthers, racial politics and convictions. And John Clutchette was none of the above. He wasn't an activist. He wasn't a Black Panther. He had the misfortune of not understanding the message that a Afro conveyed in the 60s. And so John Clutchette was wearing an Afro. And in the 60s, to white America, the Afro spoke a message of radicalism and violence. And, incidentally, as we spoke earlier about history, if you don't know this history, you don't understand when you see students today being expelled because of grooming policies. You don't comprehend yet that what we've done in this country is operated since the 1700s or off a system of racial hierarchies. And what we do is say on the hierarchy that if you are white, you are the standard of excellence. You are pure, you're innocent, and everything else is measured against that. And if you are of color, you are not just going to experience consequences, but you're going to experience a hereditary life of marginalization. And so what Clutchette did was associated himself with the people of color group at the bottom. And the way life works for those folks is that there's always a consequence to color. And the consequence for him and all of the other folks in 2024 who have these grooming policy violations is that they were not identifying with the top of the hierarchy. So they didn't look like that standard of excellence that the country has taught us all that we're to embrace. And so that Afro associated him with this radical movement in the country called Black Pantherism. And I'm not calling it radical because it's certainly not radical to me, but to white America and to prison officials, it was radical. And so with Clutchette's case, the way I entered this is that I had just spent about 6 years of my life working in Louisiana on the case of the Angola Three. And I worked on the release of two of those three, Albert Woodfox and Herman Wallace. And with that particular case, their entire conviction rests upon their association with the Black Panther Party. No ballistics, no eyewitnesses. The state just manufactured stuff because they were Black Panthers. So once that came to an end, I started reading John Clutchette's story in the magazine and understood immediately that he was a California version of Angola 3. So I reached out and I said, I'd be interested in getting access to your prison records because I have a theory. And I didn't tell him what my theory was, but my theory was that his conviction, again, was based on politics and association and fears and not based on any legitimate claims. I was right in the end because what his prison record showed is that the day this guard was murdered inside of Soledad prison, John Clutchette was actually not in the dormitory where the murder happened. He was physically in another building visiting his mother. He didn't tell me that. I'm not telling you that. The prison records told all of us that. So his actual records exonerated him. So once I saw the records, I started trying to understand why would anybody ever believe he committed this crime? So when I did the digging, I saw that the jury didn't believe it because they didn't convict him. They didn't convict anybody. However, after he was released from this, he reoffended and went back into the system. Well, most of the system understood his name. They didn't forget the history. And because of that, when he came back in and did the second sentence, he was ready to go home, but the governor would not allow him to leave. And the governor was trying to punish him for the fact that he had not gotten convicted because of the Soledad murder of the guard. So the governor did all of us a favor because the governor wrote in the denial for parole. And this is a man who all of the law enforcement community was on the parole board. They agreed with paroling him, but the governor gave his reason. And in his reasoning, he said, basically, this is to punish you from what you did back in the 70s. And of course, this is in 2017. So my students and I contacted his California lawyer, who was extremely committed to this case, who did an amazing job. And we explained that we wanted to help, but we did not want to get in his way. And so to try to avoid all of us stepping on each other, we allowed him to continue his work in the California courts, and we pursued ours through the international realm. And so what we did was file a human rights complaint on behalf of Clutchette. And ultimately, the pressure, I believe, that built in conjunction with the very compelling pleadings that his lawyer was filed led to his release. So he is now out, and he is amongst us still, and finally experiencing the freedom that he was due all of those years. So I want to, say in that story that one of the lessons that I've learned over my course of lawyering is that if you don't have what John Clutchette had, and you don't have what the Angola 3 had, which is an organized advocacy team, separate and apart from your organized legal team, and also access to media, access to international coalitions of folks who will partner with you and take a stand, oftentimes you will never see justice. And so that is one of the things that inspired me to write the book Under Indictment, because most people truly don't comprehend that you could actually have no evidence and convict a person. And most people truly don't comprehend when they read that a person has had an appeal, that they've had post-conviction. They don't comprehend that really is not somebody thoroughly reviewing those cases. That is merely former prosecutors, in many instances, giving deference to former prosecutors, which is what the law says they have to do, by the way, and conducting a sniff test. So it's a sniff. Hey, does it smell wrong? That's all that is. And so people believe that when they read that this person has had an appeal and they've had all these different reviews. In fact, about a month ago, I sat in the hearing in Louisiana. I was watching Jason Williams, our only progressive district attorney in the state, be tortured and lynched by members of Louisiana's legislature and other folks from the with the political agenda. But in that process, what I'm listening to is the will to silence any voice that wants to champion justice and to really review cases and give a quality review. And because he was giving a quality review through the only civil rights unit that exists in the DA's office in the state of Louisiana, he was threatened. His power was taken, the law was changed so that he can't do those types of reviews. So what this tells us now is that there are people, as we just witnessed this week with this execution, who have no interest in justice. Their interest is in convictions. Their interest is in cash. And the way the book describes it is really like an assembly line. It's mass production. Just keep the thing moving. Don't stop, because every time it moves, we're bottling something that's going to be profitable. That's really what justice has been reduced to in the state of Louisiana. And really, from my experience in all of the southern states, you don't see radical differences in any of those states. So what I am hoping to do is educate lawyers and non-lawyers of the way the justice system works for people of color, because those narratives that exist now are false, and there is no counter narrative to challenge that. And so that book, Under Indictment, serves as that counter narrative to start to educate people, but more importantly, to inspire them to reimagine something that actually works and works better. And that example does exist. So the book explores some systems that used to fail and that no longer fail. And the book talks about how did they go from bad systems who over incarcerated to systems that actually work. So that's the inspiration for the book, and that's the work that I did on John Clutchette. So all of these little projects over the years sort of fueled a desire in me to help people understand that what was convicting all of these men in these cases that I've worked on is a common denominator, which is they didn't have resources. They were men of color, and a lot of these cases were political prosecutions. So, in other words, some government official just doesn't like your viewpoint and they want to silence you. And so I wrote the book after years of working on those kinds of cases, saying that law schools are not teaching this. The public is not learning this. Somebody needs to pause and tell this story so that we can inspire future folks to come and do the work once I'm not doing it. And because I need help getting it done.
Yeah, true indeed, true indeed. I just got one last question. You had mentioned about non-lawyers. What are some things that people can do that that haven't went to law school? Because a lot of people take it for granted. You don't understand the law until you kind of get into them situations, or you have family members that are already going through that process and they don't know what to do. But are there things that people can do before
Yeah.
things like that happen to try to make change?
Yes, and that is the purpose of book 3, which is called The Summons. And again, that will be out in November of 2024. But that book is an advocacy how-to book. So it is written for that lawyer or non-lawyer who wants to be trained to fight a system that harms. In the criminal legal system, the most immediate thing people can do is not avoid jury service. Because we know, because of research now, that people of color are often the people who raise reasonable doubt in these jury boxes. And just like they are attempting to suppress the vote when it comes to people of color, there is a simultaneous movement to suppress the presence of people of color in the jury box. And what is the jury box? It's a voting body. And so you can sort of see the overlap, which I call the marriage between the jury box and the voting box and the public elections box. Those political rights are all wedded and they overlap. So being a part of jury duty is a crisis at this point. The second thing that people can do is I'll tell through an illustration. I do some restorative justice work with the Louisiana Black Panther Party, the members who still survive, who are alive. And one of the things that is a great illustration of what people can do is the police department in New Orleans wanted them out back in 1970 when they were a very active presence in the state of Louisiana. And so they manufactured a reason to go and serve a warrant and try to, kick the door in and shoot them and kill them. That's what they did all around the country. But something beautiful happened in November of 1970. The community who knew the Black Panther Party because they depended on them for food and for security and for cleanups. That community, when they saw law enforcement come out in mass numbers with tanks and all type of military equipment, the community came out of the Desire Housing Project almost 5,000 strong and stood as a buffer between the Black Panther Party house and, of course, law enforcement. So law enforcement had a decision to make. Do we do this and kill 5,000 people potentially, or do we retreat? And they decided to retreat. So that is a powerful testament to what people can do when they physically take a stand in defense of other people. So that example tells me that if we understood our human connectedness, we would never, ever walk by anybody who is being dealt an injustice. So our mere physical presence serves a powerful warning to anyone who wants to cause an injustice that they will not get away with killing one. You have to kill 5,000. So that is one of the other things. Is not just wear that Black Lives Matter T-shirt and show up after there's a dead body on the ground. If Black lives really matter to you, you show up anytime somebody's uncomfortable because they're being done wrong in this country. Again, I mentioned Jason Williams, the only Black DA who is progressive. And as he was going through this public lynching in Louisiana's legislature, he did it largely alone. There were small pockets of people who showed up, but that legislature should have been disrupted that day. That should not have been allowed to happen. And I'm not suggesting that Donald Trump, overthrow the building kind of disruption, but I mean that it should have been painful and uncomfortable for people to do what they did without an audience watching, monitoring, and being willing to say that this is your last week in office after what you just did. So being present, writing letters is something the public can do. A lot of what I cite in the book is back in the lynching era. In Reconstruction, you have Black lawyers back then who took the risk of writing letters and organizing letter writing campaigns to ask Congress to come down to Louisiana to stop these folks from preventing us from sitting in the jury box. So writing letters, when you do it in an organized way, collectively, those things carry power. Making complaints to the Department of Justice, going and making sure that you don't ever ignore any local election, because local folks have power over your local life, over your daily life. And so when you know that this person has an agenda to not allow you to have books in school and not allow you to be able to walk the street freely, this person should never be holding public office, because that undermines everything that the Constitution promises to people. A simple vote could overdo that type of injustice. Being a person that is a thought leader, that is something that is missing in the communities of color. And when I say a thought leader, somebody who has that history, that historical perspective, that analytical wisdom, that radical thought mind, to be able to advise people of what's happening before they can see it, so that they can organize in advance and not after the fact. So the book Summons the Summons will give you from start to finish, these are the things that you can do. And also it will explain to you why you ought to do it. One of the dedications to the book is to the Maroons. In particular, Juan St. Malo, who is one of Louisiana's Maroons, who said, look, I'm not going to be a slave. That is not going to happen. You won't enslave me. And I'm not going to spend my life trying to fight a system that you started. I will start my alternative universe. And so what Juan St. Malo did was, as a Maroon, say, I'm going to disrupt. I am going to agitate. And he started Maroon communities in the marshes of Louisiana, and did it to the point of success. And how do we know he was successful? Because the whole government went after him. They wanted to kill him because he had built a system that was highly successful, and it was competing with their system. And so I offer Juan St. Malo as a dedication to inspire people to understand this was a man with no resources, no social media, no education, but just to understand that I'm not going to be complicit in my own oppression. That's all he had to offer, and he acted and did it very effectively. So I am charging people to understand that you don't have the right to just sit and observe. You don't have that right, especially when we understand that our ancestors never sat and observed. They actively agitated, disrupted, challenged, resisted. And so I am calling on people in that same spirit to do the same thing, but to do it in a way that is legal, impactful, tactical, and effective.
Wow, that was phenomenal. I really, really appreciate you. Man, I'm still processing the stuff that you were saying, but it's very true. Thank you for coming on the platform. This has definitely been an honor.
Thank you so much for having me. I am a believer in what you are doing, and I am a lifelong partner with you. So just always let me know how I can support your efforts.
Yes, indeed. Yes, indeed. And I appreciate your patience. I don't know if you heard me earlier. I'm in Africa, so my setup is a little out of whack because I just got to Madagascar, so I'm trying to get it together.
That's all. What you're doing, I say, it's called marooning. Just keep it up. Don't stop. No matter where you are, don't stop. And so thank you for what you have done, and I appreciate the opportunity to speak with your audience.
Yes, indeed.